Hi, I'm Anna Denton-Jones from Refreshing Law Limited, and I'm going to talk today about constructive dismissal. Constructive dismissal is just a piece of jargon that describes the circumstances where it's the employee who's walking away from the employment relationship, either with or without notice, because of the conduct of the employer. The statutory position is dealt with in section 95(1)(c) of the Employment Rights Act, giving the employee the ability to take this kind of action. But the key case on it is Western Excavating and Sharp, and that's proposition or authority rather for a situation where the employer has done something that goes to the root, we say, of the contract of employment. It's a fundamental breach of contract, entitling the employee to treat the contract of employment as what we lawyers call repudiated. Now, an employee faced with a situation where there has been some kind of treatment that goes to the root of the contract has the ability to do one of two things. They can either accept the fact that their contract has been breached and consider themselves released from employment, or they can choose to waive that breach of contract by the employer and continue in employment. If they do that, we say that they have affirmed the contract of employment. Now, there's been a recent case dealing with this whole issue involving Morrison's supermarket, and the case involved a chap called Chingrove who raised a grievance initially because of some treatment that he'd received in work in relation to his race. And he felt that his grievance wasn't being dealt with properly. So in the end, he raised the matter with head office, and head office just referred it back to the HR manager in his local area, and he felt that she really wasn't doing anything. So sort of usual story that sometimes happens with grievances, he ends up on the sick. And eventually, because nothing's been done about his grievance, he chooses to resign and brings a complaint not only of racial discrimination, but also unfair constructive dismissal, which is what we're interested in today. Now, the original tribunal that dealt with the case felt that because he'd left it 6 weeks before he chose to resign, that he'd actually affirmed his contract of employment. So he appeals the case to the Employment Appeal Tribunal, who've looked into the case law in this area as to when somebody is deemed to have accepted the contract of employment, when there has been some kind of fundamental breach of it, versus when they can be said to have legitimately resigned as a result of the employer's treatment. They've pointed out that it's not just a question of time, it's also looking at the whole context of what's going on. In Mr. Chingrove's case, of course, he was off on the sick, so he hadn't done anything in that 6-week period, such as going back into work, that would have been seen as affirming the contract. And they pointed also to another case from Bournemouth University, where they pointed out that, of course, the longer you've been employed in an organisation, and perhaps the more senior you are and things like that, the more serious a decision resignation is. So it's got to be reasonable for somebody to take a little bit of time to think long and hard about what they're going to do before they actually take that step of resignation. So they didn't feel that 6 weeks was actually particularly long in these circumstances. The Employment Appeal Tribunal have referred the case back to another tribunal now to reconsider all of the issues and all of the facts based on this guidance from the Employment Appeal Tribunal. But I think it does show that it's not just a question of saying that the employee must act very, very promptly and quickly in resigning if they are going to claim constructive dismissal. Of course, one of the big lessons from the case is also to do with the employer and the way they deal with a grievance. You really do need to pick up on grievances swiftly, be seen to be dealing with them and come to a conclusion within a reasonable time frame rather than drag things out, because you are only likely to face criticism for doing that. If anybody's got any questions about today's session, please do email me. It's adenton@refreshinglawltd, all one word, .co.uk. Thank you very much.